that you want to try to protect them from in their own lives, or in their families' lives potentially too. So there are a lot of things that you can do to really make sure that they are the best equipped to deal with those problems, and that what you're leaving them does not cause them problems and doesn't in any way become available to their own liabilities. This is a lot of the planning that we do here because it's so important, especially when you have children in high liability careers, or you just have other life concerns for them, or you just really want to protect them no matter what. So there are certain things that we can talk about doing with family members and how they inherit to best protect them. It's something that a lot of people aren't aware of that you can do. And unfortunately, if a plan isn't properly set up, there's not a lot there to allow it. But welcome, everybody. I'm attorney Justin Randall here with Hooper Law Office. And our topic today is protecting those that you love, a very Valentine's Day friendly topic coming up this weekend, I believe. So what I mean by protecting those that you love is there are certain things that you can put into an estate plan to make sure that the people you're leaving assets to are not either negatively impacted by what you're leaving them, or you're protecting what you're leaving them from some of their own possible liabilities that can come up. So if you're participating via Zoom, you'll be receiving a couple of materials from us after this webinar at the end that talk about the certain, it's kind of a chart of the things you want to protect them from either from themselves or from others. And it's just a helpful kind of tool to look at and the types of things that you can protect people from. So if you are participating via Zoom as well, there is a Q&A function. So if you have any questions that come up as part of this, please feel free to submit them, and I can see them come up as we're talking. I'm here to answer your questions, so please feel free. And at the end of the webinar too, you'll receive via email a feedback form from us. So if anything I talk about today leads you to say, hey, I really want to get my plan looked at, or I don't have a plan and I really want to get one in place, or I just want to talk some more about some of my concerns about my own estate plan, that gives us a place for you to mark down that you'd like us to reach out and set up an initial consultation. Those initial consultations are complimentary, so they don't cost you anything to come in and talk to us. We usually schedule them for about 2 hours to really sit down and get to know you and your situation and what's going on in your family's life as well, because that's really the biggest part of anybody's estate plan, not so much the money side of things. I guess to get started, we'll talk about kind of the protection aspect of things. And when we look at it, we think of, okay, how do we protect beneficiaries from themselves, and how do we protect them from others? Because there are various things that can come up in someone's life that you either need to protect them from if it's a behavioral issue on their own end, or if it's a legal liability or a creditor issue, something like that on the other end. The biggest problem that can happen in people's estate plans when they don't factor those types of concerns in is they think, well, right now my child is fine, there's nothing going on, and they'll probably be fine for the rest of their life, they're responsible, but they don't factor in the things that can pop up that they weren't anticipating, or if their initial beneficiaries passed and now that beneficiary share goes down to grandchildren that you didn't even contemplate them having issues at that time. There's a story that we often tell when we're talking about that protection that I'll get to in a second, that I think really highlights that need to at least have it in there as an option for your family to utilize. So when we're talking about protecting people from themselves, what we're generally talking about is, like I mentioned, some sort of behavioral issue, or in particular, a substance abuse issue. What you really don't want to have happen when you leave money to somebody is you don't want to leave it to them. Especially if you know that they have that sort of issue, you don't want to leave it to them directly, because you know that they're going to possibly use it for their substance abuse issue, or if they are, just spendthrifts, they're really bad with money, that can be another issue as well. Maybe you don't want them to just blow through everything that you leave them, all of that. Another thing that we try to protect people from, almost across the board, regardless of even if they're the most responsible, young adult in the world, is age. We try to protect them from youth and from that sort of impulsive decision making that can come with being young. Even the most responsible 18-year-old in the world is probably still not totally ready to handle a large amount of finances or investment decisions. The founder of our firm, Voss Hooper, always jokingly says it's not a matter of an 18-year-old inheriting money. It's not a matter of if they'll buy a Corvette. It's a matter of what color that Corvette is going to be. That's the only thing that's up for debate at that point for that young adult beneficiary. So there are things that you can put through an estate plan, some terms that you can put in there that say, hey, if someone is underage, and by underage, I don't mean a minor necessarily, although that can certainly be a part of it, but I also mean underage by your own terms. You can set the age at which somebody can be in charge of their own inheritance. You can say basically until somebody is usually 25 is the minimum I would recommend. Until somebody is the age of 25, they cannot be in charge of their own inheritance. I'm naming, somebody else that I trust, some other adult or organization to manage those funds for that beneficiary until they do reach age 25. And I do think that they're responsible enough. So that's one thing. I mean, even like I said, and that's not even a negative thing against that beneficiary if we're just talking about age here, because we're all impulsive, generally speaking, when we're very young. So you're just not yet ready to handle a large amount of money potentially. Another thing I mentioned, protecting somebody from themselves, is substance abuse issues. This is a really common thing that can create a huge issue for a beneficiary, and for the family who has to figure out what to do after that beneficiary's inherited money. This can be substance abuse issues that you saw in advance. Maybe you already knew about them, but it also includes, and in particular, it's important to think about those that you're not aware of or that haven't come up yet. So that story I mentioned, I was going to say earlier, this really kind of highlights the need to be aware of this, or at least think about how this could be dealt with through your own estate plan. There was a family who came into our office to talk to us about this. The planning had been done, 20 years ago or so before they ever came in to talk to us. But the parents had gifted the home over to their 4 kids. So they had now their 4 kids being owners, and think they originally had done this to try to get it out of the hands of, being available for nursing home expenses, things like that. So they, in one side of things, protected it from their own concerns. But then what they did not think about is, okay, now our 4 kids, as owners of that property, are opening, we opened it up, our home up to their own liabilities. So that can include things like what happened in this, by the time both parents had passed away, 2 of their 4 children had passed as well. So one of those children that passed, that 1/4 went according to their estate plan to their spouse, because that's what their will said. It said that, honey, I love you. Everything you get, or I leave through my estate, goes to my spouse. So that meant now that 1/4 of the parents' home was owned by an in-law, because that's where their 1/4 ownership went according to that daughter's estate plan. So this was not so much an issue in that they didn't trust the child, or the in-law, excuse me, but they weren't super thrilled about it either. Obviously, it wasn't what they thought would happen. And just as a reminder, I'm bringing up a lot of, I guess, complex topics and concerns. So, please feel free to use that Q&A box if you do have any questions. I will be able to answer it as we go through. So that's what happened with the one daughter anyway, that, son-in-law now owned 1/4 of the property, and he was responsible and nice. So that wasn't, he wasn't going to cause problems there. But where the problem really crept up was that another of the daughters had passed as well. and she was not married, didn't have any estate plan. So everything went down to her one child, their grandson, the parents' grandson. So at the time when they did this planning originally, the grandson was, a really small child, I think 5 or so. And they could not have possibly have foreseen the issues that would come up for that child as that child aged. Now, 20 years had passed. That child was, 25 or so, and had developed a very, severe substance abuse issue. And it came time to sell the home. After both parents had passed away, all the kids wanted to just be out and sell it. But their issue was, well, how do we stop this, our nephew in this case with the substance abuse issue? How do we stop him from using those funds to harm himself or to fuel his substance abuse, or his addiction? And the problem with that scenario that they had found themselves in is that they can't prevent that from happening, because that grandchild of the original parents had not factored in any sort of protection, any terms in an estate plan that would stop someone like that grandchild from being in control of any inheritance. That grandchild was legally entitled to the funds of that 1/4 ownership of the sale, because they were now 1/4 owner of the home. So this just really highlights those types of things can pop up. So it's not just protecting your own direct beneficiaries from these types of issues and, protecting their inheritance from these sorts of issues, but it's also looking at, what if they pass before you, and how does their plan, their own estate plan say, well, where do things go? Or what does your estate plan have as backup beneficiaries? And do you have any provisions in there that say, hey, if anybody meets any of these definitions or these situations, and our, either our personal representative through our will or our trustee through our trust, can they use their own discretion to say, I don't think, our grandson John should get, be in control of the inheritance because of the issues that John has in his life. So those are the types of things that you might want to protect somebody from, from themselves. Another kind of similar one where it's sort of a cross between protecting someone from themselves and from others is, if somebody you have as a beneficiary is either a child with special needs or is receiving any sort of means-based assistance from the government, such as Medicaid or any other program like it, like a SSI, for example, that you don't want that person to inherit directly. You don't want them to just, as grandson John, who's on Medicaid and receiving assistance from the government, you don't want them to necessarily just inherit in their own name with full control without proper protection planning in place, so that those whatever assets you're leaving to that person, that they do not harm the benefits of your beneficiary. Because a lot of times with this, yes, they're getting money, which helps them in ways that the benefits do as well. But the issue is really more so, what if the money kicks them off of the benefits, but those benefits were providing a lot of other things that money alone just isn't going to cover? This is particularly more of an issue with children with special needs. If they're on any sort of government assistance, that also includes like caregivers or learning opportunities, things like that they wouldn't, the money itself is not going to replace. It can be a huge disruption to these people to just leave them money outright. Now, that does not mean, though, and this is a common thing that people think you have to do, but that does not mean that you have to disinherit these people either. Especially with children with special needs, a common misconception is, oh, I'm just not going to leave anything to them, I guess, because it'll cause them harm. But there are ways to deal with that where they can still receive the benefit of the inheritance and be protected from losing all of their benefits. And after I go through some of the other things that you're going to want to protect people from, I can explain kind of how that would be done. So moving on to protecting people from others, this tends to be the more common concern for a lot of people, is how do I protect my kids or my beneficiaries from, the kind of bad forces out there that are going to maybe want to get their hands on what I'm leaving my kids. So a really common one is divorce. People are concerned about. Inheritances in general receive some protection from being divided up upon a divorce because they are not generally considered marital property. But the issue that people run into a lot is when they just inherit assets as an individual and say, I inherited it in my own name, and then put it in, all that money into a joint account by, you know, with me and a spouse. Well, then what is individual property anymore? It becomes commingled. It becomes very difficult to tell what is just mine and what is marital property. So when you set up the proper way for one of these beneficiaries to inherit, you can make it so that it is borderline impossible for them to ever commingle it, and therefore, gets extra protection from a divorce, and they're under no obligation then to split it up upon a divorce either. So that's a big one. Another is, children in high liability careers or who have other legal issues ongoing. So high liability careers being attorneys, for one, medical professionals, doctors, things like that. The people who you hear about getting sued the most, right? For malpractice issues, things like that. Well, if you leave somebody like me or a physician a bunch of money, and I ever had any sort of liability come up where that physician ever did, for example, well, that inheritance may be subject to those liabilities if it's just in my name. So you want to make sure that that beneficiary does not have to give up what you're leaving them for those liabilities. And it can be, like I said, totally responsible people who run into these liabilities too, because, what happens if it's a car accident and somebody sues you, or, as a physician, it's medical malpractice. There was a bad result from a surgery that may or may not have been that doctor's fault, but now they're getting sued for it. Those types of things. So it's not just responsibility that you want to be aware of, but also, if there's any chance that these people could run into a legal liability like that, do you want them to have to give up their inheritance for it? Divorce, lawsuit liabilities, things like that, but also creditors. If somebody, once money comes to somebody and it's just in their name, it's subject to all of their individual liabilities again. So if somebody had to file a bankruptcy, whether it was because they're spendthrifts themselves, or they have a medical bankruptcy that they didn't foresee happening, which that tends to be the most common type of bankruptcy in the country, I believe, is medical bankruptcy. So, again, people who could be totally responsible, but had a health event that they now have to spend through everything and give up everything that they inherited, that you left them and intended for to benefit them in any way. So these types of things that you're not, they may not be an issue now, and they may not be ever be an issue for your initial beneficiaries. But if one of those beneficiaries passes and it goes down to a grandchild or a backup beneficiary that you've named, and that person develops one of those issues, or runs into an issue with a lawsuit or a bankruptcy, you're really running into things that you could have protected them from, but you have to have the right provisions and plans to make sure that that happens. One last thing that we're, when we're protecting someone from others, a big thing is, long-term care expenses. And I've actually seen this work now where somebody's parent had passed, left them, the proper terminology in their inheritance, and it was inherited the right way, and everything was funded correctly to that inheritance. And they were concerned about one of their spouses, their liability as well, because the spouse was going into long-term care. Well, that spouse, their care did not, was not in any way going to impact that inheritance, because the terms of that inheritance said that they, the beneficiary, the wife, was under no obligation to use it for those expenses, and nobody could attach liens against that inheritance or, force them to give it up in any way or recover against it after they passed. So it really protected that spouse and allowed them to live a little more freely and without as much concern about spending down through everything for Medicaid and nursing home expenses. One thing as well that one of our attorneys had a story they had told me was that they had done planning so that somebody's child would be able to retire, because they had they had an event in their life that they had lost pretty much everything they had saved up for retirement. And then, they were now in their 50s, or, mid to later 50s, maybe. And they were thinking they'd have to keep working forever because they just didn't have anything anymore, enough to retire. And that the way that inheritance was set up, because they also had some creditor issues ongoing, made it so that they could retire. They could fall back on that, and they could, enjoy the rest of their life in the way that they should have been able to begin with. So, there are a number of issues where these types of things can come up, and whether or not you can foresee them doesn't mean you shouldn't plan for them. Like I mentioned, there's plenty of times where people have the most responsible kids in the world right now, or, they will always be responsible, but maybe their grandkids aren't, or the ones that they were too young at that time to know whether they would be responsible. You couldn't have foreseen what happens down the line. So the most important thing with that, whether you're using a will for your estate plan or you're using a trust for your estate plan, is to make sure that those documents say, if anybody meets, any of these sorts of situations, that we don't want them to be in charge of their inheritance because of responsibility issues, or we don't want them to be able to have to ever give it up for liabilities. You need those terms in there. Without those terms in there, it can be very difficult to receive that same effect. And this leads me to a really important point as well. Just because those terms are in that plan does not necessarily mean that that's going to be the end result either. Because what happens a lot is people do not have their estate plans properly funded. And what I mean by that is, when you're using a will or you're using a trust, there are certain ways that you either need things titled or that you need things beneficiary designated to make sure that those plans actually control those assets. So if you've ever been joined one of our probate webinars before, you'll know that we've talked about this a lot. But wills, a lot of people don't understand that when you have a will-based plan, you're really telling everybody that, hey, I only intend for my assets to go through probate, or I intend, the bulk of my assets anyway, to go through probate. And the reason for that is wills are specifically a set of instructions to probate of how you want your assets divided up. So if you have things on beneficiary designations, or with beneficiary designations, like on IRAs or life insurance is where you tend to see them the most, those actually pay out directly to those individuals. They don't go through probate at all, which also means then that they're not necessarily, going in accordance with your will either, because if they don't go through probate, the will has no ability to control them. So it's really important then, if your will says, I'm going to set up a trust for my child, that you have things either go through probate so that that trust can be properly funded, or you have the right beneficiary designations on there that point to that child's trust rather than to that child as an individual. So when I was talking about how do we protect these children or these beneficiaries from these sorts of concerns, really the most common way we can do that is by having them inherit a trust from an estate plan rather than inherit as an individual. Because with those trusts, that's how you really place those restrictions on, who can be in charge, what age someone has to be, and what the usage of that trust can be for. So that's how you can say, well, if somebody is subject to creditors, they are not, allowed to attach any liens to this trust, or you cannot force them to pay out to their creditors, things like that. And the same thing, unlike a will, but in regards to having a trust for yourself, if you have that trust, you either want to make sure that as much as of your assets as possible are actually owned by that trust during your lifetime, or are otherwise designated to that trust after you pass. Because again, just like a will only controls what's going through the probate process, a trust only controls what it owns. If everything avoids that trust and it just, again, pays to those individuals directly, you're not really using your estate plan. This is a really common problem we run across with when people come in and maybe it's been 20 years since they've come in, or they're new clients and they may already have documents of their own. When we actually take a look at their assets and how they're designated or how they're owned, they don't at all follow the terms of their estate plan. So it's really easy to get this sort of false sense of security when you have a will or have a trust, thinking, "Oh, I've got this. It's all taken care of now. This is going to direct everything after I'm gone." But then the actual designations on their accounts or how things are owned don't follow those terms. They're under no direct control of those documents anymore. So it then therefore also avoids any of the protection planning you have in place. A recent example that I had heard from somebody was that a plan had been set up and it said, okay, I want my 3 children to inherit in asset protected trusts so that they don't have to give anything up to creditors or anything like that. And the bulk of this person's estate was in IRA funds. And the financial institution that managed that IRA, we request verification when we send out updated beneficiary designations to make sure that they are actually changed. And the institution sent back the verification and said, "Hey, this is correct. We did it the way you said." Well, what it turned out had actually happened is that they still just named the 3 kids as individuals rather than following our instructions to, so that it would go with the estate plan and actually go into the asset protected shares of the estate for the kids. And, there were no real ongoing issues with these kids that was overly concerning. But the problem is it still didn't go in accordance with their plan. So in order to protect those that you love from themselves and from others, it's not just having the right terms in the document. That is absolutely essential. But it's also about making sure that you can, actually have what you own be controlled by your documents that you're using. Because, I always sort of frame it this way. If you're paying me to set up a plan for you, you don't want to have just a really expensive piece of paper. You want that plan to actually work for you. So, it's very important to make sure whether you have these documents in place already or you're looking to get these documents in place, that if your concern is to protect your children or your beneficiaries from these sorts of problems that can pop up, that you do so, and that you bring that up with the person setting up your estate plan. So we are almost out of time here, so I will start to wrap up, but I don't see any questions. But again, if anybody has any questions or ones they didn't feel comfortable asking while I'm live on air or anything like that, you can always email us at learnmore@hooperlawoffice.com. And our next webinar coming up next Wednesday is actually 5 ways to leave a legacy. So our whole theme this month is leaving legacies and protecting those that you care about, in the spirit of Valentine's Day and all of the love and caring feelings around that. So please feel free to join us next week as well. Again, just one last reminder that evaluation form will be sent out to you at the end of this. And if you do want to set up an initial consultation with one of the attorneys here, myself or any of the other attorneys, you can feel free to fill that out and return it to us, and we'll reach out to you to set a time up. Thanks all.